How are you? I was watching this course on entrepreneurship and intellectual property strategy. It appears to be an amazing course, and the I went through the course structure as well. It is amazing, but I have few questions to ask you and few instances which I want to discuss with you. Can we discuss it now?
Yeah, yeah, please, Priyadarshini.
Yes, ma'am. Ma'am, so there's one thing, one instance which happened here, the place where I'm staying because of this COVID situation. So I met a small school girl. She is in third class. So one day, what happened? Her mother was cooking, and as I have already expressed that I stay at a very remote location. So her gas, cooking gas, LPG gas was out. They did not have any of it. So we were just discussing next day in the park sitting together. She said, Didi, I want to develop something where I can actually gauge that when is my gas is going to be over. So I thought this is amazing idea for a third standard kid to have. And then I was watching this videos of the course, and it occurred to me, can we convert this idea into any intellectual property, which latter can be taken as a proper business idea or entrepreneurship can be developed on it. So this was the one instance which happened. And next was I was reading some piece. There was a blog which I was going through. So it said that there were students or small kids from a slum area because of this COVID situation and lack of money. They don't have access to the face mask or face shield, which is very much needed right now. So what they did was they took this 2 liters of water bottle of soda and they empty water bottle, they cut it out and they made a face mask out of it, where they did not remove the lower part or the neck part of the bottle, and they just cut it in a way that the bottle opens and they wear it, and they have this bottle opener, like the bottle neck at the bottom, so they can open it and have a straw and drink anything and then close it in such a way. So it was a very nice idea which I was reading about. So I just wanted to know your opinion on intellectual property behind these things, and can we take them as an idea for entrepreneurship or not?
Okay, okay, Priyadarshini, what I have understood it is like that. Ki one example you have given of a LPG and another example of a soda bottle you have given. So the I guess the case is like that. The school kid want to solve a problem concerning that LPG gas gauging, and the second was like a plastic soda bottle, and they have used it to prepare a face shield kind of a thing. Yes, definitely these are the innovative ways, and what we can say, this is a frugal innovation in one way. So these kids have tried their level best to find out the solution, a very optimum solution with the available resources. And yes, definitely it is a good innovation, but when we are talking about a patent, we have seen that there are certain criteria for a patent, and we know that 3 criteria are there, that is novelty, non obviousness and industrial applicability, and we have to check that whether these criteria will be followed in this particular case. And for novelty check, obviously we are always dependent on the search report, and we have to see exactly what exactly they have done, and then only we can give the clear cut opinion about that. But yes, in this case definitely we can at least this is the innovative way, so we can consider it, but the industrial applicability is definitely there. Then the non obviousness part, it is little bit what we can say we have to check, and the novelty part we have to check. So if we see these two parts, then only we can give opinion about it. But yes, this is a definitely a frugal innovation kind of thing. So
Okay.
patent is like probably I will say no, but yes, we can, if they work on it further, yes, definitely that can be considered for patent. But at this stage I will say that clear cut, based on the information whatever you have given, I will clearly say that no for this, because yes, novelty, non obviousness issues are there. Okay. So but there is a good try that yes, the students have tried their level best to find out the solution, and when they will go and think in that direction, and they will try to solve such kind of things, definitely that will create something which will be patentable. And yes, it is a starting point, we can say, definitely. Yeah.
Okay, ma'am. So from here, I would ask you one more thing, which is, any person who is having no background about intellectual property or entrepreneurship, or is new to this whole line of business or these terminologies, how would you tell them that what is the difference, or how entrepreneurship differs from business? Is there any difference, or they are just two varied term of same for same thing? Is there anything of that sort which you can explain to me to make it a little clear, just like a person who doesn't have any background for all these things?
Okay, okay. So it's like you want to relate entrepreneurship and a business, or is there any difference? And yes, we have to see how IP is coming in between this entrepreneurship and a business. Am I right?
Yes, ma'am. Yes,
Okay,
ma'am. Yes.
so the thing is like this, that when we are talking about entrepreneurship and when we are talking about a business, a minor difference, or I can or you can say the difference between these two, it is like that, that entrepreneurship is like a it is a risk taking scenario is there. The problem is there, and that problem is taken and that problem is solved by the entrepreneur. Now, this entrepreneur may be at any level of any age, any gender, whatever it may be. So, that is a entrepreneurial activity, and we have already seen that there are a number of definitions given about a entrepreneurship. When we are talking about a business, generally it is like a business is like a set scenario is there, and the major object is like a profit making is there than the problem solving. Already something that means in the entrepreneurship you are solving problem which is a high risk, and you are trying to get the solutions for that. And in the business, it is the motive is generally to make a more and more profit, and there what we can say that everything is set related to that particular thing, and in what we can say increasing profit is like a major objective, or that is there in the business. But how IP is coming into the picture? It may be an entrepreneurial activity which is like starting with a risk taking, problem solving and all kind of thing is there in the entrepreneurship. And in the business, yes, they are doing the daily activities which they are giving some services or some products they are giving, and yes, they are doing that business. Whether IP is coming in both the what we can say in this both the activities which are going on, yes, IP is coming in both the in these both activities obviously, because we have seen the in one of the session we have seen that yes, we have given you the list of this is the references of Professor Grandstand. He has given that table and we have shared that thing with you, and we have given you that okay, business idea is there, that is a trade secret. If technology related thing is, it is something a patent kind of thing. If customer list is there, that is something a copyright thing is there. So, we have shared that particular thing, and we have said that whatever activity is that entrepreneurial activity or any business activity, whatever you are doing, yes, IP is there and you are coming across that particular thing. Now, the question is how you will judge that whether IP is there or not, and for that you can refer that session where the list of various activities whatever you generally are following, it is giving, and related to that whatever IP is there, that is given, so that you can easily relate the activity whatever you are following and whether IP is involved in that particular thing. So, yes, means you can say that most of the big organization and all that, they have started with the very challenging problems. We have seen the example of Google, we have seen the example of Biocon, we have seen the example of Arvind Mills, and now they are like a big organization, the set businesses. Now they are like more on giving the yes new offerings, that new things they are offering, and all obviously they are making in their business a profit. So, this thing is going on, and these are the good examples whatever we have seen, right, Priyadarshini?
Okay. Yes, ma'am. Whatever you explained is very clear. So I can very safely say that the concept of intellectual property can be equally exploited by an entrepreneur as well as a businessman.
Yes, 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 yes.
Okay. So, ma'am, my next question would be, I want to know what is, how can you explain the difference between innovation and invention? Although we
Oh,
have taken it up in the module, I have seen it, but
okay.
still I want to hear like a crisp difference so I can, make out very clearly if somebody says in one sentence, tell me. So something of that sort, if it is possible.
Okay. So, when we are talking about innovation and invention, yes, there is definitely a difference, and I guess in that module, wherever we have dealt with, we have asked this question, and we requested you to just find out what is the difference between innovation and invention. So, innovation, we have dedicated 1 week on innovation actually, if you have gone through, and invention we have dealt with when we have seen the patent, we have seen the invention and new invention also. So, that two things are there. So, the thing is like this, that invention, it is like we are taking it more towards in a legal aspect, we are focusing there on a patent law or a Patent Act 1970, and in Indian Patent Act 1970 section 2 deals with a definition. So, mostly all means mostly it is a scenario that in any act, generally it is not always, but generally section 2 is always dealing with the definitions which are which will be used in that particular act. Okay. So, invention, new invention, both these definitions you can find in the section 2 of a patent act. Now, what that invention is? Invention, we say that it should have a, I am just giving you the, I am not using legal language, but I am using a normal that layman language you can say, and here you can say that invention, the word, the another word which is used in the act, that is a inventive step should be there. So, we will just see what is invention, new invention and inventive step, all three things we will see, and then we will see innovation, so that you can get idea about that particular thing. Now, what exactly invention is there? That okay, we are concentrating on the we have already seen that 3 criteria are there. So, novelty aspect is very important, and we have already said that it should be first time in the world. So, that is a novelty aspect, and we have given you the example of a patent searching, and how with the help of a patent searching we have seen that that patent searching will give you the idea about a novelty. Now, when we say that novelty part is there, like the novelty part is when we are examining, and then when we are examining that thing, we say that whether really there is a some inventive step is there, some move from that current scenario to the next scenario is there, that we have to check. And who checks that? Yes, examiners check that. We also check that when we are filing it, so that we get the confidence whether our patent will be granted or not. So, that check is necessary when you are filing for the patent, and therefore, Priyadarshini asked a question or given the examples about the kids who are doing. We say that we can't clearly say something about the patent, whether it is patented or not, because we said because we have to check here that novelty aspect is a very important, and in this case novelty and non-obviousness, these two aspects are little bit what we can say not that clear, and therefore, the probability of patent is very less, but yes, that is a frugal innovation. So, that innovation is there definitely, something is existing and that is modified in such a way that its value is increased. So, that value addition is there by doing some activities, that value addition is done, that we call it as like a innovation. So, some manufacturing line is going on, some product development is going on, or some what we can say the activity related to the design aspect of that product is already there, but you have made some changes in that and you have achieved some addition, value addition into the product. Probably it may give some returns in the form of money or not, that is the other question, but you have done that addition. So, that is something whatever you are changing in whatever available, we call it as a innovation. In short, just to we have to understand the concept. So, I am giving you it in this simple language than giving you into the that clear management or a legal language, that okay, something is going on, I have made it in such a way that yes, it's there is a value addition and I am saving my time or some money or the appearance, something I am changing, that we call it as a okay, that innovation is there. But when you are talking about an invention, it should be like a first time in the world, and there I have to check again that whether it is really a novel. I will check a search report and then only I will give you the guarantee that yes, it is really a first time in the world or not, and there also we are not giving 100% guarantee, because that 18 months timeline is there in patent law, and we or nobody knows how what are the different patents filed within that 18 months window, and therefore we say that okay, 99% whatever search report is given, it will be valid, but we are not sure about that 18 months time. So you have to understand that invention is really a tough thing, and we if you want to patent it or you want to get a patent or patent protection, yes, you have to work hard to make it like that, that it should be first time in the world. Now, one more thing I will add, that sometimes what happen that you make a changes, something is going on, you make a changes, that incremental changes are there, but that incremental changes may give some economic benefit. If that economic benefit, if you are getting substantial economic benefit, that substantial word is very important, if you are getting that particular thing, then we can say yes, yes, there you can consider that yes, patenting is possible. So that thin line is there where you have to think of a patent and how whether that innovation will qualify for a patent filing and all that thing. But yes, with the experience and with a discussion with an expert, yes, definitely you can gauge that particular thing and you can go for a protection, and we have to do that protection in well in time so that we will not lose the priority. So I guess Priyadarshini, I guess I am able to give you idea about invention, new invention, innovation, and then its relation with a patent.
Yes, ma'am.
Is it fine?
Yes, ma'am. Yes, ma'am. Yes, ma'am. It's fine.
Yeah,
And ma'am, what about trademark? Like, I know trademark is something which we register for, and then we get, and we have discussed the criteria and essential elements of it in the module also, the third week, if I am not wrong. So, ma'am, how do we differentiate? Is any difference between trademark and brand? Like we say that Zara is a brand, Apple is a brand. I am pretty sure they are protected through trademark as well. So how would you explain that? Like why, if it is just trademark, so why do we have a different term as a brand? Or is there anything underlined in them which is, which actually substantiates or is between them as a difference?
Yeah. So I got the point, that what you want to say, that is there is a difference in the brand and trademark. Am I right?
Yes, ma'am.
Okay. So the point is like this. Yes, brand and trademark, when we are talking, we have to just see, one is a marketing aspect, a management kind of aspect is there, and other is trademark is a legal aspect. So the first basic difference is here. It is like a trademark is like a protected by a statutory act. That statutory provision is there. There is a act, and that act is giving a protection, legal protection to that particular word, logo, letter, whatever it may be. We have seen the different kinds of a trademark. So that protection is given by a statutory protection is given. So that is what the trademark is, and you have to do registration for that particular thing. That is a trademark. When we are talking about a brand and we talk about a brand image, you say that brand, that any business is there or any activity which is carried out, or maybe celebrities also, they say that, or you sometimes say that okay, I have to maintain my brand or something, I have to maintain my image kind of thing, right. So generally means this is a language we are using, many times you probably have observed that particular thing. So what exactly the difference between them is like this is something which is getting a legal protection, and brand is like you are creating the value to that name, that the name which is given to the business, we are creating value. Now trademark can be a, what we can say, if I want to put it in a simple way, I will say that brand is bigger umbrella kind of thing is there. So under that bigger concept or bigger umbrella, trademark is one part there which is like a legal protection of that particular name. Branding is something much more than that particular thing, and therefore so many things are involved for brand. Means when we are talking about a brand, the marketing aspect comes into the picture very much, and then the advertisement, you know that with the help of a advertisement, that brand building is done, the information about the brand is given to the public through that advertisement. Then the other thing is like you are creating that goodwill by offering kind of a the whatever offerings are there, it may be a service, it may be a product, but that offerings whatever you are doing, that offering will create a goodwill in the market. Yes, that will come, that will be counted, or that will be considered when you are thinking about a brand such as such. Then obviously when you are talking about a brand, and in one of the module we have mentioned that you decide the positioning of your product, and therefore we have given, I guess, example that Apple when they are offering their products, they have clearly decided their customers, and they always expect a premium class is our customer. That is kind of a what we can say, the mindset is there in the offerings of Apple. Or when we are talking about a particular brand or particular that name, you just take an example, when you say Alan Solly, or when you say that say Peter England or Rough Tough, you can immediately identify the customer class related to that particular name, right. So, although the name is there, so the brand building is there, that image building is done where all things are involved, like a customer opinion, then the market, and then the goodwill, and the how company services are there, everything will come into the picture. But trademark is a one part within that, you can say, which is given a legal protection, so that if anybody try to infringe that particular thing, you can take immediate action on that, and you can, that statutory provision is there, and you can take legal action against that particular infringer immediately, and therefore trademark is very important. And so what the thing happening in one of the module, in upcoming module in the copyright, you will come that the case study of Sanjay Leela Bhansali is given. Now you can say that okay, Bhansali production is there, or we have already seen that Arvind Mills is there, or Biocon is there, or that Google example we have given. So when we are saying Google, that Google as a trademark, that value will be different, that trademark value, and it's a brand image is totally what we can say, a bigger picture is there, and yes, that will be a what we have to take it as a marketing aspect, and this you have to take it as a legal aspect. That major difference is there. Okay, I guess Priyadarshini, is it okay, or you would like to add anything into this?
Yes, ma'am. It is. I can totally figure out now the contouring of trademark and brand. So it can be said that IP can be the core of it, and then the marketing and the advertisement and the value addition to it is basically brand building, and that is
Yeah,
called as brand.
right, right.
So IP has to be the core of it, but that is the
Not
case.
necessary core, but I will say that yes, it is important because that gives you a legal assurance kind of a thing. So that way it is very important. There are some businesses which are without trademark registration. Generally the local businesses are there, if that very local businesses are there, probably they may not do that trademark registration, or they do not know about a trademark, but that goodwill is such a high that they are doing a business based on that goodwill. So we can say that brand image is built by that business in that particular area. So that kind of thing is always there. Okay.
Okay. So, ma'am, that means IP actually contributes to the net worth of a company.
Can you repeat please?
So that means IP actually contribute to the net worth of a company.
Yeah, net worth, yes, definitely. When you are talking about intellectual property, it is a one of the intangible asset of the organization. It is a asset of the organization, and yes, definitely it is a contributing into the asset or the that net worth of the organization. Definitely it is contributing. Yes.
Okay. So, ma'am, and I was, consulting with few of my friends, and we were doing this course together. And there are few questions which I wanted to ask on behalf of them, and there were few other learners also. On the forum, I saw they had few queries, so I wanted to put them here as well.
Yeah, please.
So, ma'am, there is one doctor. He is currently working with AIIMS, and the videos which you keep referring in the module, that roadmap for patent creation.
Okay.
So he mentioned that he has gone through the whole course, and he said the whole lecture was extremely valuable for him because he has been working in this technical field for a long time,
Mm-hmm.
and then he contacted few patent attorneys as well.
Okay.
So and they charged almost a lakh of rupees to him as the sum of this whole process, patent filing process.
Mm-hmm.
And he is little new to this field, so he
Okay.
was not sure whether this thing is going to work out for him. So he was saying that he has a novel device already ready with him, but he is not sure that whether he is ready to find patent for him the complete specification for the device, and how can he file the examination report for it, for a request for examination. So he is a cardiologist, and he has designed that
Okay.
device, which he's finding few difficulties because of the stage of clinical trial which we have in medicine field. So he has withheld the filing of this particular patent. So he just wanted your input in this, that how if you can help him in this whole process.
So, thank you, Priyadarshini, and we should congratulate doctor that he is like trying to do a patenting activity, and here what we have understood is like that he has paid something like a 1.7 lakh for that patenting activity. And I will say that in one of the modules in the RFPC, that is a earlier course, that is a for a roadmap for patent creation, we have dedicated one. In the one discussion we have already said that what is the generally a fee and how exactly the process goes for a patent filing. And we have seen that okay, right from 50,000 to maybe 1.25 to maybe 1.70, this is a little bit higher end, but yeah, means that fee range is there. But we will say that when doctor who is like a very much what we can say the different field, but he is using that instrument, and he do that innovations and creates that instruments, definitely that instruments are generally innovative, and generally they are like pass the criteria of patent, because these are the people who are continuously using these machines, and they know that what is there and how it can be, how better that can be done. And therefore if that activities are done by the users who are a continuous user of that machine, definitely generally they pass the invention criteria. So what we will suggest you in this scenario like this, that as we always insist you that you concentrate on that provisional filing, and in the provisional filing what you can do is like in whatever way in the way you are writing, there is no any format for provisional. If you want to follow a certain format, then you can follow the format of a patent, which is in the earlier module, that is in the earlier course, that is RFPC, we have given the, I guess it is week 3 and we have week 2 or week 3, there we have given the details about the parts of a patent. And based on that, if you could write down the provisional application, no necessity of writing a legal language, nothing, just take it as a framework, write a provisional application, do not write claims, it is not required in provisional, and create a provisional application. The caution we are taking in the provisional is like that, as much as possible we have to just expand that invention or whatever you are offering is, so that it is easier to narrow down, but we cannot add anything into the patent, provisional patent. Once means when we are doing the final thing or complete specification, we cannot add anything, we can remove, but we cannot add. And therefore when you are filing provisional application, we have to keep it as broad as possible, keep it broad, do that what we can say the write it in your own language, in own way, no techno-legal language, nothing is required, and file a provisional application. And once you file that provisional application, I will suggest you the easiest way is like that. Suppose you are a part of say one organization as a medical this thing, maybe or you may be an individual, whatever may be the scenario, but you can collaborate, you can contact directly with the, if you are very much confident, probably you can contact with IIT professors, or you can contact with maybe a good engineering college professors where good lab or good research is going on, because probability is that there you can get good intellectual input for that particular machine related thing, and that can be a joint venture kind of activity, and probably that will help you to do that joint activity. And out of that joint, and it is very necessary that suppose suppose you are from one medical college, and suppose you collaborate with a engineering college, that will be a good combination, and you can come out with a very good instrument. And if you have done the provisional filing, you need not to worry about that particular thing, you are getting a 12 months. This is a one way, but here you are doing a fine tuning of your product or something like that. And provisional filing is very simple, very less fee, that is 1650 is a fee for that, that way you can do. Second option, suppose it is in a conceptual mode and you are still like not done anything for that particular instrument development. So, it is a time taking activity, that 12 months window period is not there, it may be a longer. So, at that time I will suggest that, yes, here again the collaboration I will suggest that please find out the people who are working, and I can give you the example here that in IITs many people are working on a medical instrument. So, or medical problems, in every IIT you can find one or the other professor who is working on the that medical related instruments, or you can find out any engineering colleges where exactly the such kind of activity is going on. And yes, I guess that will be a good collaboration, a joint activity, and you can have some MOU kind of arrangement in between that college and wherever you are affiliated, and then you can take that research further, and then you can develop the further products in collaborative way, because unless until we collaborate, probably it is not possible, because two different fields are there, and both inputs are very important here, and therefore, we will suggest you that collaborative activity here, and probably that will help. And if engineering colleges like IITs are there, we have a complete IP system very well settled, and we have the processes which are set, online processes are there, and we have already our policies, and yes, we can I mean say that case to case basis, the things like the revenue sharing or that inventorship and all that things are already taken care. So, I guess that will be a good what we can say way to move fast in the research or developing that particular instrument. Alone, or if you, the other way means, this is a one way is there, academic collaboration. Other way I will suggest that MSMEs are there. So, micro, small, medium enterprises, and we have seen, means I have worked with MSMEs, and I will say that are the other, means this is another what we can say a very good source for a collaboration, I will say, because these are the people, MSMEs are like working in that particular domain for a longer period of time, and they are so expert in that probably and they have already their market set and their vendors and all, means whatever that collaborations, their own collaborations for their production, that thing is already set, and therefore, it will be probably very easy for you to find out that MSMEs, and any local MSME if you could find out, and if you could collaborate with them, that will be another easy way. This is a second way for that. Now, the third way I will suggest you that file up some project proposal kind of thing. So many government this proposals related, means research related grants are available. You have to give the proposal, and then you have to go through that process of that they follow certain procedures, and that is also one of the way. But I will say that the first two ways are little better, because, and the second way is more better, because MSME have already their production in the market. So, that is the most what we can say the easy way to bring the product into the market than the academic collaboration. But yes, academic collaboration will give you the good inputs, and I will not say that academic collaborations are not going into the market and all that thing. Yes, they are also going, but the maybe one stage more is there than the MSME actually. So that much difference is there, and again it depends on the the particular lab or particular MSc. We cannot make generalize that particular thing. I am giving you a general background. So if we concentrate on that means person to person, or that company to company, things are changing, and therefore we have to when you are collaborating, you have to do a proper due diligence, and then only you have to enter into that. But yes, once you find out that one good collaboration, definitely you can have a series of patents, and you can have that good IP portfolio, and yes, that will be very much benefit to the society also. So actually thank you for your question, and congratulations to you for developing such kind of instruments. And if you have any further if you, I try to give the answer, but if you have any further queries, please do write to us. We will try to help you in our own way, whatever it is possible, and that way it will be probably better for you to develop your venture. So I guess Priyadarshini, is it whether I am able to clear that particular thing, or
Yes,
you want to add?
just one more query to this. The third option which you said about the government grants and projects with the government research facility. So I just have one small question in that. If I write the project proposal and if I apply for the grant, so what do you suggest? How much of information regarding my patent I should be giving out, or should I first file for the patent and then go out for the research grant seeking, or how should I do this? Just
Right.
maybe in 2-3 lines.
A very important thing actually. So when we are dealing with proposal writing, you have to take care that see, if your venture is in a conceptual mode, it will take time, 3 years and 4 years. So at that time it is not possible for you to think of a provisional application and all that thing. So here I will suggest that when you are writing proposal, don't disclose, please listen carefully, don't disclose the crux of that invention, whatever you are thinking. But yes, you can give the background for that, and in the proposal you will not give the details and all that thing. That caution we have to take. So that is very much important, because we never know your proposal will be passed or not, who is seeing that thing, whether confidentiality things are taken into care. As a caution, we should take care in that way. I am openly saying that thing. I know means that we have to take caution. So because we have to keep the confidentiality, it is something our intellectual input. So that is a skill, actual proposal writing, and we have to be very careful. So I will suggest that maybe the first and second way will be the better than the proposal writing, because sometimes it may work or sometimes it may not work. So therefore first or second ways will be better than the last way, I will say. Okay.
Okay, yes ma'am. Yes ma'am. So ma'am, there is another thing. As we were discussing about brand and trademark earlier, so it is seen in one of the module that you said Microsoft has 56 billion USD as its trademark valuation. But when we look at the valuation of a company as a whole, it goes around 300 billion USD.
Okay.
So, is this how do you justify the statistics? Like, is it just the whole valuation of the company, or how do you explain this to any person who is new to this field?
Okay, so it is like a for trade that we have given that it is a something around $56 billion for Microsoft, and somewhere the amount is coming something like a displayed like or in this like a $300 billion or something like. Am I right?
Yes, ma'am.
Okay,
300 billion USD
so the
for
thing
the
is,
whole company value.
Yeah. So this is we have seen the difference of a brand and a trademark actually. So within that means brand image, yes, 300 billion or more is absolutely possible, and not possible, it is there, and it will grow further. definitely, because as as the reach and the offerings are what we can say, they will do that, add into that particular thing. When company is going to add into that, definitely that value will increase. Now, and along with that, trademark value is different. We have to just understand, we are talking about a trademark valuation alone. Trademark valuation, that particular trademark, how much it costs, that we are calculating and that we are talking about. And brand value is, yes, as I have told you, brand value is much more like an umbrella, and within that, trademark is a small part. Along with trademark, that goodwill and other intangible assets are coming into the picture, and that will form that brand value, and definitely that difference will be there. But we have to appreciate that $56 billion brand value, $56 billion this trademark value itself is a good amount actually. Brand value, definitely it will be more, because goodwill will be added into that, and then the other things that will be added into that, and yes, that will increase. So, definitely there will be always difference, be huge, this is huge difference, that huge difference will be there, okay. Always it will be more.
Okay. So, ma'am, so that means a company valuation is inclusive of maybe many intellectual properties which own, and trademark valuation is just the trademark itself.
Yeah, yeah. So, you see, we when we are talking about a valuation, means this company as a whole, we are thinking, if you see the balance sheet of company, you can see that there are intangible assets. So organizations are reporting that intangible assets, and trademark is one part, patent is another part, then industrial design is other part. So everybody will have that, means every component will have that particular valuation. So these all kind of IP will come into the picture. Then goodwill is making a major chunk actually, and then the whatever the other intangible assets, like a potential, what we can say, capabilities of that organization, all that thing will come into the picture. So majorly goodwill and these intangible assets in the form of IP, all IPs I am talking. We are just given example of a trademark, but all IPs plus this goodwill, that value is like a, it will obviously come a bigger amount. Yes.
Okay. Okay. And ma'am, as we have seen clearly just in this week, we were talking about patent. So the lifespan of the patent is said to be 20 years. That is, the protection offered for patent is 20 years. Then what about trademark, copyright, industrial design? Is there anything, any similar concept for these IPs?
Okay, okay. So the total duration or validity of that IP you are talking about, am I right?
Yes, ma'am. Yes,
Okay.
ma'am.
So actually, the validity or the time period of every IP is different, and we have dealt with in every week. We have when we are dealing with a trademark, we have given you idea about a trademark. We have done with the patent, we have given you idea about a patent. Then in the next week you are dealing with a copyright, so you will get idea about a copyright, and then in the 6th week we are dealing with the industrial design, there you will get idea about a industrial design. But to summarize, I can give you the what is the picture. So you can say here, it is like a, for a patent it is a 20 years, anywhere in the world you go it is a 20 years, and it is like a starting from a priority date, and then there are family patent and all. We will not go into the details of that. We have to check from priority date, that particular 20 years, that is for a patent. No other timeline is there, or timing that duration is there in a patent. Trademark, if you take, it is like a only IP which is renewable, and it is after every 10 years you can renew that particular thing, and it can be have then indefinite life until you will renew it, that will be continued. So that is a beauty, or that is a very good what we can say aspect of a trademark is. So this is patent and trademark. When we are talking about a industrial design, it is like a, first you can file it, then you will get the time period is for 10 years, and you can extend it maximum by a 5 years only. We have dealt in industrial design that thing, you can get the idea. So this is for a industrial design. When we are talking about a copyright, and this timelines, whatever 3 timelines I have told you now, patent, trademark and this industrial design, it is like a this patent and trademark, it is all over the world this thing is followed, in any country this thing will be followed. Now, industrial design, this concept or this kind of separate dedicated act is in India. In USA there is a industrial design patent is there. So, that way it is going into the patent category, and here we are talking about industrial design 10 plus 5 years. Okay. Now, when we are talking about a copyright, there are three, I will say, categories are there. Copyright is there, then related rights are there, and in related rights there is a broadcasting right and a performance right is there. So, the timeline is a different for all these three, you will see it in the week 5, but to give you idea, copyright, it is the subject matter for copyright, whatever the subject matter for copyright is, what is subject matter and all, you will get the details, but the timeline is like a lifetime of the life of the author plus the 60 years. Then for related rights, that is broadcasting and performance right. For performers right, it is a 50 years, and for a broadcasting it is a 25 years. So, one more point I will say that here, that copyright timeline changes according to country. It is not like a patent. For patent it is universally 20 years, for trademark it is like a universally, means anywhere in the country you go 10 years it is renewal is there, but for copyright the timeline is changing, and you will get idea in the copyright week what that timeline is. Okay. So, I guess Priyadarshini, this is good enough for timelines, and I have clarified for all 4 types actually, and then the other IPs are there for GI and all, or plant varieties, that timelines are different actually. So, maybe we are not dealing with these IPs here, so we will not include it here. Okay. So,
Yes,
I guess
ma'am.
this is good enough, right?
Yes, ma'am. This is good, and these were few of the doubts which I had and my friends had, and other learners also mentioned that they have this doubt. So, and ma'am, there's one request I wanted to make. A lot of us are new to this course, and we have no idea about that RFPC course, that Roadmap
Okay,
for
okay,
Patent
okay.
Creation course, which is, repetitively we came across in the lecture series. So I would request if we can get there the link in on the discussion forum, or somehow if we are provided with the link, it will be very helpful for us. So if that can be done.
Okay, okay, we can give that link actually, RFPC one link, immediately we can add it into the discussion forum.
Okay, yes, ma'am. Thank you so much. And ma'am, there are a few other questions, and I'll try to reach to you with them as well very soon. And thank you so much, ma'am, for this session. I
Okay.
actually it was looking forward to it, and it was very good that you explained everything so clearly. Thank you so much,
Okay,
ma'am.
okay, okay, okay. So, I guess we have covered a few questions here. There may be a few more questions are there. We will find out the different ways by which we will try to answer, and definitely we will answer that during the course time. Okay. So, thank you
Yes, ma'am.
Priyadarshini. Thank you. Thank
Thank
you.
you so much, ma'am. Thank
Okay.
you.